Just when you thought things couldn't get any more interesting, the United States Supreme Court decides to toss Roe versus Wade right into the garbage, into the dustbin of history where it belongs. We're going to unpack exactly what happened. We have the opinion. It is 98 pages, and this is a draft opinion, something that we're not even really supposed to be seeing these days, but we are going to go through it. Since it's out here, we might as well look. It's 98 pages. We'll hit the highlights. We're also going to spend some time unpacking the other very interesting side story, which is the fact that it leaked in the first place. Chief Justice John Roberts calling it a betrayal. And I have been alive for 30-something years now, and I've never seen anything like this. Many people speculating that this was an intentional leak trying to throw the court one direction or another, causing major cascades of consequences for not only the Supreme Court, but also the entire legal community. So we'll talk about that. And there are reactions already taking place throughout the country. Supreme Court saw many protesters. Looks like those may continue to be heating up. And we've got reaction from a number of different elected officials, people like Hillary Clinton, McConnell, Elizabeth Warren, shaking mad over this. We're going to start by going over to Politico, which broke the headline for us, an exclusive reveal. They published this late last night, and when I saw it come across, I thought there's no way this is legitimate. There's no way this is real. I've never seen anything like it, but it's true. Apparently, the Supreme Court has voted to strike down Roe versus Wade according to the initial draft majority opinion. So it's not official yet. They're still passing this stuff around, and we can see exactly what it looks like. It's got the word first draft on it. We'll piece that all together, and we're going to go through and actually look at the opinion. But the immediate impact of the ruling, as drafted in February, would be to end a half-century guarantee of federal constitutional protection of abortion rights. It says no draft decision in modern history of the court has been publicly disclosed while it's still pending. In other words, this is not the official verdict, right? This is not their order. They haven't come to an ultimate conclusion. It could still go the one way or the other. It's looking like we know the balance of the power of the court, and we know it's probably going to go as this is written, but it's still a little bit shocking. The unprecedented revelation is bound to intensify debate over what was already the most controversial case ever. So let's take a look at the opinion. We can see here, first draft circulated February 10, 2022 to a number of different judges. It's written by Justice Alito, which is a Republican appointed judge, somebody who is traditionally seen more conservative of the judges. And here he is sending the first draft over to a number of different other judges: Thomas, Breyer, Sotomayor, Kagan, Gorsuch, Kavanaugh, and Barrett. We can see them all listed there, along with Roberts, the Chief Justice. And that's all 8 of them. So they're all getting to look at this and say, hey, we agree with this. We're going to join your opinion. We are sort of in agreement with your opinion. We're going to write our own concurring opinion. So we like what you said. We like the ultimate outcome. We're going to vote in favor of you, but we're just going to do it for different reasons. We say that the underlying constitutional justifications in my mind are different than your mind. So I'm going to concur, but I'm going to ultimately vote with you. Or if you're going to be somebody named Sotomayor, Kagan, or Breyer, which I paused on him because he's outgoing, but there's Breyer there. If you're one of the liberal judges, well, then you're going to see that they're going to write a dissent. They're going to say, this is the dumbest thing I've ever seen, Alito. What kind of moron would write something so horrendous? And they're going to write a dissent, and they're going to say, you're a big dummy. But this is not where we're at. We haven't gotten all of the opinions fleshed out yet. We don't know who's concurring and not, because Alito is just written the draft of this thing. And he's saying, here's what I'm going to probably move forward with. What do you think of it? Here are the case: Dobbs versus Jackson, Women's Health Organization. Justice Alito delivering the opinion of the court. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. You're not kidding about that. Some believe fervently that a human person comes into being at conception and abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others, in a third group, think that abortion should be allowed under some but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. So Alito is breaking this down into 3 buckets. He's saying there are some people that just say absolutely zero abortion, no excuses whatsoever. Others who say abortion should be open and free, and you can do it however you want, whenever you want, how often you want. And then there's a sort of a medium between the two, where some people will say we don't like it, but we allow it in some situations as long as there's restrictions and those restrictions aren't overly burdensome. So the court continues, Alito writing, for the first 185 years after the adoption of the Constitution, each state in America was permitted to address the issue on its own. Then, suddenly, in 1973, this court decided Roe versus Wade. Even though the Constitution doesn't mention abortion, the court held that it does confer a broad right to obtain one. It did not claim that American law or the common law had ever recognized a right, and its survey of history ranged from the constitutionally irrelevant, meaning when they passed Roe versus Wade, when that court was going through their analysis, they went through a bunch of history. And after cataloging a wealth of other information having no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules, much like that might be found enacted by a legislature as a statute. And that's been one of the biggest criticisms of Roe, is that the United States Supreme Court just kind of created the thing out of thin air. They called it a penumbra of rights. They went through the Constitution, they went through this big lengthy history lesson, and they went and picked out and selected exactly what they wanted to support their arguments. And then what resulted was a new, essentially, framework, a statutory set of rules that was coming from the Supreme Court. And many people were scratching their heads saying, how is this possible? There's the Supreme Court. They're not Congress. That's what Congress is supposed to do. They're supposed to write the rules and the laws, and the Supreme Court is supposed to say what the law is and whether it's constitutional or not. They're not supposed to write the laws, because if they write the laws, how can they judge the laws? That's why we have separate branches of government. Hello. Under this scheme, writes Alito, each trimester of pregnancy was regulated differently because the Supreme Court decided this all made sense to them. They weren't judging an act of Congress. They just created one. But the most critical line was drawn at roughly the end of the second trimester, which at the time corresponded to the point at which a fetus was thought to achieve viability, the ability to survive outside the womb. Although the court acknowledged that states had a legitimate interest in protecting a potential life, it found that this interest could not justify any restriction on pre-viability abortions. The court did not explain the basis for the line, and even abortion supporters have found it hard to defend Roe's reasoning. What the court's talking about here is that 3-trimester framework. So the judges, when they were deciding Roe versus Wade, they said, it's a really complicated issue. We want to codify this once and for all. We know that probably something like this would never pass at the federal congressional level. And so since we're a bunch of activist judges, we'll just go ahead and cram it down everybody's throats through the courts rather than the legislative bodies. And they did that. And they thought, because they were, I guess, all-knowing, powerful judges who are also aspiring congresspeople, apparently, they also were going to write this as a statutory framework. First trimester, no restrictions on abortion at all. Second trimester, maybe some restrictions because it's about to become viable. And then the third trimester, the states have a lot more interest in regulating abortion because it's getting closer to viability. In broad strokes, one prominent constitutional scholar wrote that he, quote, would vote for a statute very much like the one the court ended up drafting if he were a legislature, but his assessment of Roe was memorable and brutal. He says Roe was not constitutional law at all and gave almost no sense of an obligation to try to be. It didn't. If you read it, it sounds like a bunch of legislators who just got together and decided, well, this sounds good. There's 9 months in a pregnancy, and so we can just break that up into thirds and 90 days, 90 days, 90 days. Sounds like sort of a different government program. So it worked for them, and they created this monstrosity, and they passed it as law through the court. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that process. It imposed the same highly restrictive regime on an entire nation, and it effectively struck down the laws of every single state. Then we fast forward to Planned Parenthood versus Casey. The court revisited Roe, and they changed it a little bit. We see here it's a very complicated opinion, but 2 judges didn't want to change Roe at all. 4 others wanted to overrule the decision in its entirety. They said this doesn't comport with the Constitution whatsoever. And the 3 remaining judges, who jointly signed the controlling opinion, took a third position. Their opinion did not endorse Roe's reasoning, meaning they didn't say, oh, that 3-trimester framework that you idiots came up with was a great idea. It hinted that one or more of its authors might even have reservations about whether the Constitution protects the right to abortion. But the opinion concluded that stare decisis, meaning that one opinion follows another. The courts like to have consistency in their lineage. They don't want to just be flying all over the place. One day that's free speech. The next day, no, it's not. One day that's a legal thing to do. The other day it isn't. Now it's legal again. You're going, what the heck's going on here? So they try to have consistency, and the concept of stare decisis, you're following precedent, which calls for prior decisions to be followed in most instances, required adherence to what it calls Roe's central holding. So he's saying that Casey was really trying it really hard to bend itself into a pretzel to try to comport with Roe, even though it knew that Roe was not good law. Says that a state may not constitutionally protect fetal life before viability, even if that holding was wrong. Anything less, the opinion claimed, would undermine the respect for this court. So they're saying that we have to adhere to bad law in order to protect the court's legitimacy. Alito is saying, well, that's weird. He writes, paradoxically, the judgment in Casey actually did a fair amount of overruling. You were saying that you were trying to adhere to its central holding, but you didn't. Several important abortion decisions were then overruled in toto, and Roe itself was overruled in part. It says Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin called the undue burden standard. We learn all about it in law school. And so they said this 3-trimester framework's a little bit weird and wonky and, not really the purview of the Supreme Court to do stuff like that. So we're going to get rid of it. And now we're going to have a new framework called the undue burden rule, meaning if a state has an undue burden on a woman's ability to go get access to an abortion, then that is an unconstitutional rule because it put an undue burden on that woman. But where did that come from? Well, they say it came from Roe versus Wade. Well, where did Roe versus Wade come from? Well, nobody really knows. It's called a penumbra of rights that sort of emanates out of the 14th Amendment, due process and all that stuff. But it's not really anywhere. And we're going to see that that's Alito's point. He says, as has become increasingly apparent in the intervening years, Casey did not achieve the goal of making this more clear. Americans continue to hold passionate and widely divergent views. Some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy. Others have tightly restricted it even well before viability. And in this case, 26 states have expressly asked this court to overrule Roe and Casey and allow the states to regulate and prohibit pre-viability abortion. So more than half the states are now, according to Alito, asking the Supreme Court to take action. One of those states happens to be Mississippi. They're saying, Supreme Court, can you please uphold the constitutionality of a law that prohibits abortion after the 15th week of pregnancy, several weeks before the point at which a fetus, currently under the current legal framework, is regarded as viable outside the womb? In defending this law, the state Mississippi came forward and said we should reconsider and overrule Roe and Casey and once again allow the state to regulate abortions as they please. On the other side of this, the people who are filing the lawsuit, respondents and the Solicitor General, ask us to reaffirm Roe and Casey. They say that the Mississippi law cannot stand, allowing Mississippi to prohibit abortions after 15 weeks, but before that sort of viability stage, they argue would be no different than overruling Casey and Roe entirely. They contend no half measures are available. We must either reaffirm Roe and Casey or not. So Alito says, fine, those are my choices. How about this? We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely. There it is, the Due Process Clause of the 14th Amendment, which, if you read it, doesn't say anything about abortion in there. That provision has been held to guarantee some rights that are not mentioned in the Constitution. But any such right, quote, must be deeply rooted in this nation's history and tradition, implicit in the concept of ordered liberty, if it's to really stand out. The right to abortion does not fall within that category. What category? The deeply rooted in this nation's history and tradition. Is abortion necessary? Is it within that category? Deeply rooted in this nation's history and tradition. How about this? Is the right to abortion implicit in the concept of ordered liberty? Alito says no. He writes, until the latter part of the 20th century, such a right was entirely unknown in American law. Go back through the records, through the history books. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from other rights that this court has held do fall within the 14th Amendment and the protection of liberty. Roe's defenders characterize the abortion right as similar to those other rights that we recognize elsewhere, like intimate sexual relations, contraception, and marriage. And these are other rights that the court has said exist. And it also doesn't talk about many of those things in the United States Constitution, but they go back and they say, well, you know, marriage and things like contraception and sexual relations and the intimacy that exists behind those. Well, there are protections that you can sort of lump into the Constitution, because we do talk about things like due process and equal protection and all the rights and liberties that are conferred. And if you had all of those rights and liberties, but you couldn't have intimate relations with somebody in your bedroom or something without being arrested, right? That's legally, there are certain things that can happen in those contexts that are problematic, but you get my point here, right? We want to make sure that when we establish baseline civil liberties, that they are covering the behavior that we sort of expect them to cover. Here they write, abortion is fundamentally different than those things, as both Roe and Casey acknowledge, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. So it's a little bit different than two people getting married, or a little bit different whether somebody has access to contraception, or it's a little bit different than whether two consenting adults are engaging in legal, lawful, consensual activity. These issues involve unborn human beings, which is different and requires a different standard. Stare decisis, writes Alito, the doctrine on which Casey is relying, they're relying on Roe versus Wade because they just wrote it. And they say, well, if we deviate from past rulings, that could be problematic, but we're not going to do that. Alito is saying that just because they wrote Roe versus Wade doesn't mean they have to follow it. He says that does not compel unending adherence to Roe's abuse of judicial authority. They're judges. They don't get to write the laws. They're supposed to interpret the laws. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of this issue, this has inflamed the debate and it's deepened the division significantly. It's time to heed to the Constitution, writes Alito, and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting on it. Written in the Casey opinion by the great Judge Antonin Scalia, rest in peace, concurring in the judgment and dissenting in part. He says, this is what the Constitution and the rule of law demand. We scroll down to the bottom of the opinion after some serious legal analysis, and we see Alito writes, we end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. And I think the converse is true. If they want to allow it and legalize it, they could do that also. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. The judgment of the Fifth Circuit is reversed. The case is remanded for further proceedings. It is so ordered, Judge Alito in the Supreme Court of the United States. If this lands, it's going to be a spicy meatball. Now, the judge also included Appendix A. Take a look at this. This is what he referenced previously. He said, listen, if you want to say that this is something that was embedded in the Constitution, you want to say that this was a right protected, we got to look back through the history of the United States and see whether we can identify evidence that that is true. And if we can't find evidence in the history books, well, then maybe it wasn't really so intertwined with American history and tradition, was it? And the judge, Alito, was talking about this specifically. He says, look, we go back to the 1800s. There's nothing that was lawful about this at all. Every person in Missouri who shall willfully and maliciously administer or cause to be administered anything that causes a miscarriage is illegal. Same thing, Illinois. Same thing, New York. We've got Ohio, and the list goes on and on and on. 1840s. And this was right around the time that we got the Reconstruction Amendment, and the 14th, of course, is part of those. So they're saying that when the 14th Amendment was written in there, we have to look at it relative to the context of the time. Did they include abortion rights in there when they put that in there? I don't think so. Because if you look around the country, all the other states actually codified it. They made it a crime, not more than 12 months in jail for something like that in Virginia. Even in DC, as recent as 1901, whoever procures a miscarriage of any woman, big trouble. Imprisonment not less than 3 or more than 20 years. So those are the highlights of this opinion. You can see there's a lot more to it, many pages of analysis, and the full opinion, of course, is online. The question is, how did this get out? How do we have our hands on this? And I have to be honest, when I saw this come across last night, I was a little bit nervous. I thought I was looking at something illegal. How does an opinion like this, one of the most consequential opinions in American history, leak? How does it leak? I actually didn't believe it at first. I thought, how did a Supreme Court opinion of this magnitude actually make its way out into the public? As long as I've been practicing and been alive, I've not seen anything like this. I know the level of rigor that exists in order for a person to become a Supreme Court clerk or somebody who works in that building. The amount of history, the integrity, the things that these people have to do to work in these positions, it's so monumentally gruesome and grueling that for them to sacrifice their entire future in order to leak something like this really shocked me. I thought there's no way that anybody would do something like that. Did somebody leave this at a bathroom somewhere or out at a restaurant, a dinner table? Is this a Hunter Biden situation or something? How did this happen? The Supreme Court's asking that very same question. They're wondering, how the heck did this document get out? They published a statement from the Supreme Court of the United States, published May 3rd. They said yesterday, a news organization called Politico published a copy of a draft opinion in a pending case. They say justices circulate these draft opinions internally as a routine and essential part of our confidential and deliberative work. Although the documents described in yesterday's reports is authentic, it does not represent a decision by the court or the final position of any member on the issues of this case. Of course, that's legalese. We all really kind of know how this is going to go. If everything moves forward as planned, things, of course, are now a little bit different because it has been leaked. We'll see if there's a pressure campaign that causes a judge to shake loose and change teams. But as it stands, if it's a 5-4 decision, let's say Roberts, who is sort of a squishy conservative, joins with the lefties, still 5-4, Roe's gone. If Judge Roberts, who was presumably a conservative, sticks with the conservatives, it's still 6-3, Roe is still gone. Roberts provided the following statement, and pay close attention to the language he's using here. He says, to the extent this betrayal of confidences of the court was intended to undermine the integrity of our operations, it will not succeed. Whoa, he's angry. The work of the court will not be affected in any way. Now, you might be used to Donald Trump coming out here and saying something like, we're going to nuke them to the moon, or you might be used to Joe Biden mumbling something and you're trying to understand what he said. Judges don't talk with a lot of hyperbole or a lot of colorful language. But here, he's using the word betrayal, saying they're undermining the integrity of our operations. This is like, if we catch you, you're dead, just so you know. He says, we at the court are blessed to have a workforce, permanent employees and law clerks alike, intensely loyal to the institution and dedicated to the rule of law. Court employees have an exemplary and important tradition of respecting the confidentiality of the judicial process and upholding the trust of the court. This was a singular and egregious breach of that trust that is an affront to the court and the community of public servants who work here. I've directed the Marshal of the court to launch an investigation into the source of the leak. Now, what's funny here is he says that this was a singular and egregious breach, but he's also saying, we've got to figure out what's going on here. So one leads me to believe that he knows who it is. It's a singular incident. They've already got that guy, and he is going to Guantanamo. The other one showing that maybe they are going to launch an investigation into the source and figure out how this whole thing happened. But he also mentioned the Marshal of the court. It's not somebody we hear about too often because we don't have to deal with leakers, but we do know a little bit more about them over from Wikipedia. The Marshal of the United States Supreme Court heads the United States Supreme Court Police, a security service only for the Supreme Court. Doesn't go to the president, doesn't go to the attorney general, and they serve security for all the justices personally. They're in accordance with the law. They follow U.S. code, and they have here the Marshal attends all the court sessions, serves, executes process orders, disperses funds, pays the salaries, and oversees the Supreme Court police. And also to carry out these duties, U.S. Code authorizes the Marshal to police the Supreme Court building and protect the justices, employees, and visitors. also has the authority to make arrests in carrying out these duties. So we'll see if the Supreme Court likes to keep this in-house, make their business, or if they involve anybody like the FBI to go and try to investigate what happened here. But it is a very big deal. I want to share with you a couple posts over on Twitter. SCOTUS blog said it's impossible to overstate the earthquake this will cause inside the court in terms of the destruction of trust among the judges and the staff. The leak is the gravest, most unforgivable sin that can exist. This is what Judge Scalia said to his law clerks when they came and started to work for him. He says, if I ever discover that you have betrayed the confidences of what goes on in these chambers, I will do everything in my power to destroy and ruin your career. Came from his book. Almost, he said, without a hint of regret that he had to do this. Said, I just want to emphasize something, and I'm only going to say it once. If I ever discover, I will do everything in my power to ruin your career. He just let that hang for a second. Then he moved on to other subjects. Wasn't said in a mean way, but it also wasn't said in a way that admitted the slightest misunderstanding. Certainly did not sound like he was even a little bit kidding. Again, at the time, I'm a 20-something-year-old lawyer. This is Judge Scalia, one of the most incredible jurists ever. It does not require his power to ruin my career. The amount of power in his pinky finger is quite sufficient. So as a result, I think I've never really been tempted to betray his confidences, and I doubt I ever will. He said it only once. Other than that, he was quite a genial boss. But in that one moment, you really get the sense that he was serious. And listen, I have, interacted with people like that, Judge Scalia. Nobody's ever really made that threat to me, but I've never clerked for a judge like that. But you understand when somebody says something like that, they mean it. And that's the level of gravity of the situation here. And some clerk just decided to leak it anyways. But now that the opinion has been leaked, we're getting reaction from around the country, including from our president, Joe Biden, who mumbles incoherently for 47 seconds. We're going to listen to him talk about the following. Says that Roe says what all basic mainstream religions have historically concluded. Really, that the existence of a human life and being is a question. Well, religion is very philosophical, isn't it, Joe? Let's listen.
What all basic mainstream religions have historically concluded. That the existence of a human life and being is a question. Is it at the moment of conception? Is it 6 months? Is it 6 weeks? Is it quickening like Aquinas argued? So the idea that we're going to make a judgment that is going to say that no one can make the judgment to choose to abort a child based on a decision by the Supreme Court, I think goes way overboard.
Thank you guys.
The midterm.
Okay, so that's our incoherent president. Now, typically they don't make that slip. They don't say, well, it's about aborting a kid. You don't abort a toddler. You abort a fetus. You abort a clump of cells. You have an abortion because it's just something that's not even a big deal. It's just like, going to the dentist or something. But for the president to say, aborting a child, you're going, well, yeah, that's different, because now you're sort of talking about, I think, a human child, and got to be very careful with that vernacular there, old Joe. More reaction over from Elizabeth Warren, very angry about this, and she's determined to fight on. Let's listen to this one.
Senator, how are you feeling? I am angry.
She's angry.
Angry and upset and determined. The United States Congress can keep Roe versus Wade the law of the land. They just need to do it.
I've never seen you so angry. You seem to be...
This is what the Republicans have been working toward this day for decades. They have been out there plotting,
Supreme Court,
carefully cultivating these Supreme Court justices so they could have a majority on the bench who would accomplish something that the majority of Americans do not want. 69% of people across this country, red states and blue states, old people and young people, want Roe versus Wade to maintain as the law of the land. We need to do that. And we have a right. Extremists, we've heard enough from the extremists. And we're tired of it. Thank you.
Senator, does this open the door for other constitutional rights?
Yeah, she's shaking mad, not happy about this. And that's, of course, taking place outside of the Supreme Court. We've got Leader McConnell. This is a 2-minute clip of Cocaine Mitch apparently destroying the left for trying to undermine the integrity of the Supreme Court. And we're seeing a lot of this back and forth. Who leaked this document? Where'd it come from? Did the Republicans do it? Why might the Republican conservative judges want to do it? Well, the standard thinking here is that it was a lefty, somebody who wanted to sort of show the country what is going to happen. And it's going to rattle some of the conservative judges. There's going to be a public pressure campaign from the left. It's going to cause, I don't know, Coney, Barrett or Judge Gorsuch or somebody to shake off the conservative side, join the left majority, and maintain Roe versus Wade. That's kind of the standard thinking. If that is true, they kind of did that at a pretty inopportune time. Right now it is May, and it's not a real ideal time to get a bunch of momentum behind your wings if you're a political party. You want to save that for right around the elections. We were thinking that, you know, we'd see something like this maybe in October when it serves them a little bit further, but here it's just a little bit too soon. So then maybe we say it's the Republicans, and the Republicans wanted to leak this out because they want to soften the blow. They know that this is going to cause major consequences throughout America, and they're just sort of leaking it out a little bit so that when the actual opinion drops, it's not a big deal anymore. And it's a good time, if you think about this, for the Republicans to drop this now. I mean, the Democrats have really never been weaker. Everywhere you turn, they continually lose. Trump's not getting indicted with the grand jury there in New York. Elon just bought Twitter. They're failing all over the place with the economy, probably going to enter a recession. I mean, they're losing at every turn. So if you are the Supreme Court, we put the hat on that other shoe, we say, well, maybe they wanted to leak this out because they know that the backlash is sustainable. If the country's very mad about this, so what? Nothing's going to happen. They're not going to pack the court. What are they going to do? Nothing. Or maybe it's back to the Democrats. Maybe they want to pack the court. Maybe they're saying that this is justification while they still have power in order to garner up a bunch of enthusiasm to go, now that Roe is, about to be reversed, they got to real quickly make this a campaign issue in the run up to the election. We got to get a bunch of senators in there and a bunch of House of Representatives people in there so that we have a bigger majority the next term so that we can change the balance of power in the courts and correct Roe versus Wade. Correct the egregious Republican error. Here's Mitch McConnell.
Historically, the justices, clerks,
pick it up, Mitch,
and staff have prized and protected the court's confidentiality.
All right, we get the gist of this. Here's his actual statement. We'll just read through it. It says, last night's stunning breach was an attack on the independence of the Supreme Court. By every indication, this was yet another escalation in the radical left's ongoing campaign to bully and intimidate federal judges. Disgraceful statements by Speaker Pelosi, Schumer, and Biden refusing to defend judicial independence is very inappropriate. All 9 justices should tune out the bad faith noise and feel totally free to do their jobs, following the facts and the law where they lead. So that is the Senate Minority Leader, Mitch McConnell. Here's Hillary Clinton says, oh gosh, this is not surprising, but it's still outrageous. Not surprising because she knew Coney Barrett was on there and she's going to wreck women's futures for all eternity. But Hillary, probably wanting to run for president again, this would be a great issue for her to go and elect me. And, I'm with her and I'm going to go and pack the court. Says this decision is a direct assault on the dignity, rights, and lives of women. Not to mention decades of settled law. It will kill and subjugate women. Even as a vast majority of Americans think abortion should be legal. What an utter disgrace. So Hillary Clinton's very upset about this. Now, if you actually go over to her timeline, this is pretty fun. So you click this one. Hillary's obviously very angry about this, outraged. She's a woman, and this is at the end of women. As you can see, women are going to be subjugated and killed very soon. Here, Hillary writes, women's rights are human rights, and human rights are women's rights. Isn't that poetic? She says, an extreme wing of the Supreme Court, which might be 6 judges, may seek to deny that fundamental truth. Might be 6, maybe 5, we don't know. They may try to force their views on a country where 70% of people want Roe upheld. We will not be quiet. We will not go back. So it sounds like maybe she's gearing up for another campaign. So 2 tweets back to back, very angry about this. Then we scroll up a little bit. We see she's got I think people are probably going to start changing their profile picture as it went from the mask to the Ukraine to maybe, I don't know what they use at abortion clinics, but it could be gross. But Hillary is very, very agitated about this. Join grassroots organizers in support of abortion rights at Foley Square. And then we scroll up, the next item, buy a tote bag from Hillary. Isn't that nice? So she's just schlepping her swag bags, garbage, made in China, Ukraine garbage. Says here, Hillary Clinton hats. Let's see how much this one costs. Hats and tote bags. Oh, $35 hat. That's great. Yeah. USA made, union embroidered, protect choice everywhere for $35. That's Hillary. Outside the Supreme Court, we saw a lot of activity. We see here that there was some protests that started to percolate over at the Supreme Court last night. Here is some more scenes. Well, this is interesting. Ho ho. Sexist judges got to go, I think is what they said. Here's more. Women deserve better. Keep your laws off my body. All right, we have another one here outside from Midas Touch. Protests beginning to form. Abortion is essential, is what somebody says. Pro-life, my A. Get your bands off your body, off my body. Now, we're still waiting to hear from Donald Trump and see what his reaction is. But of course, we know that he appointed the newest judge, Amy Coney Barrett, who, until Judge Breyer retires, is the most recent addition. And here we see her getting into it with Amy Klobuchar about this very issue during her confirmation hearings. She may have been the reason this whole thing is now being reversed.
Is Roe a super precedent?
How would you define super precedent? And I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall in that category. And scholars across the spectrum say that doesn't mean that Roe should be overruled. But descriptively, it does mean that it's not a case that everyone has accepted and doesn't call for its overruling.
As a judge, it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor.
And that's not the same argument that Alito's making. Alito is saying that is a garbage reason for maintaining Casey over Roe.
Senator, as the
and
book
this is Gorsuch. These are three of Trump's judges.
Explains, the Supreme Court of the United States has held in Roe versus Wade that a fetus is not a person for purposes of the 14th Amendment. And the book explains that.
Do you accept that?
That's the law of the land. I accept the law of the land, Senator, yes.
But that's not how it's going to end up, it seems. The Supreme Court making decisions the other way. So you add in Trump's three judges, Amy Coney Barrett, Judge Gorsuch, and Judge Kavanaugh. You throw in Thomas, you add in Alito, that's 5. So it's looking like Roe versus Wade overruled. If everything remains steady, unless this pressure campaign works, unless one of the judges peels off, may look like this is a foregone conclusion. We're going to continue to follow it. Another very interesting side story is, of course, how this leaked and who's behind the leak and what some of those political motivations may be and whether this has any consequence for the upcoming election or any of the primaries that are taking place right now. It's kind of a monumental shift. Remember that abortion and this issue has been really, many people say, the sacred cow of the Democratic Party for decades. And so if this is something that looks like it is on the way out, that may be some serious cause for unity, for momentum, and could be a game changer for the upcoming election. Somehow I doubt it, given the fact that everything else is crumbling around this administration. But regardless of how it goes, we'll continue to follow it. I hope you join us on that journey. If you enjoyed this content, I would love it if you subscribed before you got out of here. Would appreciate a like, and if you shared it with somebody who you also think might enjoy it, and invited them over here, because I look forward to seeing you and them on the next one.